Hi, my name is Mary Wareheim, and this is my EDL 512 Search and Research Individual Assignment. I am doing this assignment on Search and Seizure as it pertains to the school environment and how, as school leaders, we can facilitate and maintain positive teaching environments, but also be aware of the search and seizure laws and precedents that have taken place in the court system over the years. First, I found a website in which Kate Ellenberger says a very powerful quote, and she says, "Student search can be a tool for maintaining safe schools, but school administrators must balance students' individual rights with the school community's need for a safe learning environment." So there is a balance. It's being reasonable. That's a key word in the law, is being reasonable. One of the quotes she puts is, "The odor of marijuana in the hall does not provide reasonable suspicion to search all students' book bags, purses, and pockets." And that was decided in Burnham versus West in 1987. So I think that's very important to note that just because you smell something doesn't mean everyone is then forced to be searched. So it needs to be reasonable. It shouldn't be extreme measures. Another website I found online, Edwin Darden, he's an attorney, and he said the Fifth Amendment is concerned with fundamental fairness. It means that school officials cannot hold or punish a student without stating the reason and providing an opportunity to contest the charges. It's the idea of Goss versus Lopez. Darden and the courts agree that for small offenses with minimal consequences, a conference of the principal is sufficient. However, for large offenses that will warrant possible expulsion, suspension, there needs to be a full-blown hearing, just like in the court system. So Darden and the court cases agree with that. There are some major tenets of search and seizure. Firstly, we have the two-pronged test. First, a court must consider whether the search was justified at its inception. When you are a principal, if you are going to search a certain area, you let the student know that, and that is the area you search. You don't continue on a tirade and continue looking all over the place. If you are going to search a specific area for a specific thing, you need to explain that and then go through with it. You can't then go from a locker to a car to another place without saying that at the very beginning. So the first prong, a major tenet of search and seizure, is was the search justified at its inception. So at the very beginning, was it justified? Was this reasonable search? What evidence did you have, or reasonable suspicion did you have in order to go upon and start searching? And then you have number two, is a nice little segue, reasonable suspicion versus probable cause. So probable cause is different from reasonable suspicion. Reasonable suspicion requires less evidence. So you don't need a warrant in order to search. So in some cases, there's a little bit more power with that as a principal versus even a police officer. Because we are, as educators, particularly as a principal, you are required to take care of the youth at your school, and that is your task, that is your mission. Due process, this is noted in one of the landmark Supreme Court cases, but you have to make sure that you're giving, with any reasonable decision, you're giving time to listen to your students, what's going on, let them defend themselves, and explain what evidence you do have, and have a hearing. Then we have two amendments. 14th Amendment matches with due process nicely. So 14th Amendment, we have the ability to be heard before we are pass judgment upon or have judgment passed upon us. And then the Fourth Amendment protects us from unreasonable, keyword unreasonable, searches and seizures. Next, we have some landmark law cases related to search and seizure issues in public schools. A major one is Vernonia School District 47J versus Acton. And in this case, the Supreme Court decided that, especially for student athletes, you can reasonably ask them to do a urinalysis to see whether they are doing drugs in order for them to participate in these extracurricular activities. So if a student is participating in drugs, then they will not be able to participate in the extracurriculars. However, this has to be done very carefully. So we'll go into Goss versus Lopez, and that's the idea that you have to have a hearing. If you're accusing of someone of something, you have to have that due process. Then you have Board of Education of Potawatomi County versus Earls. And when we look into that, we see that the school district struck down a drug testing policy for students participating in extracurricular activities because no special need existed then for athletes. The opinion notes, however, that schools need not wait until drug use is an epidemic before implementing a testing program. So it just supported the previous Vernonia district decision. New Jersey versus TLO was another big case in the 1980s where the young lady had cigarettes in her pocketbook and she had evidence of selling drugs in her pocketbook, and that evidence could be used against her in the court of law because even though it was found during a search and seizure and it wasn't exactly what the person was looking for, it was found reasonably. It was not done unreasonably. Then you have the question about what about teachers? Can teachers be drug tested at any time? And according to Education Association versus Knox County Board of Education, yes, because teachers are seen as role models and community members who are being charged with taking care of our young ones, they must be free of drugs. So that's something very interesting I learned. So you may not, your school district may not do random drug tests, but it is within their right to do so. Some consequences, positive and negative, for future school leaders charged with enforcing and using search and seizure policies. Some positive consequences: there's definitely an increase of control and an increase to search when you're worried about something. Their reasonable searches can keep schools safe. If you are worried about someone having a gun and you do a reasonable search and find that weapon and confiscate it, you've made your school a safer place. You have more power to learn the truth in this position now with the search and seizure policies. Some negatives, because we need to keep a balance. There's an increase, it's lawsuit crazy. People sue because they're trying to get money or because they feel they have been wronged upon. So there's an increase of liability. There's also an atmosphere of suspicion when or if you are constantly searching and seizing things from people. False accusations can happen. You can hear something, go upon it, and it not happen. I saw that in some of the strip search cases where school leaders had performed the strip searches and there was nothing to be found. Large responsibility for principals, and you're losing student rights. You're losing some of your Fourth Amendment rights by the teachers and students really are losing rights because they are having to give up their privacy. So it's something to definitely consider. Next, you will see some APA references by Darden, Ellenberger, and of course the Module 5 documents which helped me create this. I'd like to real quick just go back and mention the fact that even though as a principal you may be able to search students for reasonable reasons, so like Verona School District versus Acton, there are also cases that have upheld that if it's unreasonable, such as a student, they believe they've stolen $4, that's unreasonable. And someone should not be strip searched for $4 or put into that type of situation. So, and another thing, they talked about how in the document said that if you are searched unreasonably or drug tested as a student, you're not allowed to just be drug tested because you were suspended and that's reasonable suspicion, or you think that person might have done drugs. It has to actually have reason to it. There can't just be a way to keep them out of school. That's not ethical. So it's definitely very interesting. It needs to be used cautiously. If you're going to do anything with search or seizure, like it said in the module, be prepared or kind of think ahead, be proactive. What would someone say about what you're about to do? Will it become a viral video, or is it something that can be done in a reasonable way? Does it necessarily, it should be a last resort to use the search and seizure. To keep your school safe, there are other things you can do. However, you do have that power, and if it's going to make your school a safer place, you should, consider your options if you need to do a search or seizure. Thank you.